We have legal representatives who manage to place themselves in record.
Who have not placed themselves on record yet?
Yes, Chair.
Okay. All right. Let's then place themselves on record.
Good morning, Chair.
Good morning.
My name is Johan Booysen from the Office of the State Attorney.
Yes.
I'm here to represent Major General P and Advocate.
Yes. Thank you. It's Mr. Pretorius, we need to reflect on what the implications are of the fact that the legal team of the Commission is technically briefed by the State Attorney, as I understand. But the State Attorney also represents some implicated persons. That hadn't occurred to me. It just occurs now. I don't know whether you have had a chance to think about it, but we need to reflect on it. It may be that I should not be concerned, but on the face of it, seems that it needs reflection.
I've noted what you've said, ECJ, and I'll discuss it with you later and give it some thought as to how it can be dealt with.
Yes.
Any change in any system with the Commission, unfortunately, takes time. One would not want that to be disrupted.
No, I understand that. That's partly why I'm saying we need to reflect on it.
Yes.
But equally, we need to reflect on what dangers it might pose.
Yes.
Yeah.
Now, I understand that
Because
it's a concern and we'll have to address it.
Yeah, because, so to speak, as I understand the position, the State Attorney becomes instructing attorneys to your people. And the instructing attorney has access to certain things. And in regard to counsel that they instruct. And if they also instruct counsel who represents an implicated person, what does that mean? So we need to reflect on that as well.
Yes. No, it's a valid point. We'll investigate.
Yeah.
This is the first time that I've become aware of this.
Yes. Yes. Okay. Thank you. Is there another member?
Yes.
Thank you.
Good morning, Chair.
Good morning.
My name is Johan Booysen. I'm from Maringa Attorneys.
Yes.
I would like to put myself on record on behalf of Brigadier N-Kaba.
Brigadier?
N-Kaba.
N-Kaba.
That is correct.
Okay. Thank you very much.
As well as Lieutenant General Matakata.
Who?
Lieutenant General Matakata.
Okay. Thank you very much.
Thank you, Chair.
Thank you.
Thank you, Chair. Chair, there's one last quick matter, and that is that an additional bundle is before you. ZG.
Oh yes, it has been handed to me in the past few days. I understand that it should be in the full report of the follow-up inquiry.
Yes, Chair. I believe that it forms part of the documents before you.
That will be Exhibit ZG. Thank you.
Thank you, Chair.
But we won't need it for today. Is it all we need?
We will need.
Oh, okay. All right. Thank you.
Based on the long adjournment,
What date were we on the last time? What I marked, but it doesn't look like I did.
The witness was giving evidence in relation to the Acquittal Manor investigation, which begins at Exhibit Bundle ZA, page 23.
Let me just check something before you. Okay, thank you.
Before we commence where we left off,
Major General Boycen, can you go all the documents that we have?
I think I do, Chair.
Thank you.
thank you. Before we get to where we left off on the last occasion, you will recall, General Boycen, that you gave evidence in relation to the Toshon Pandey case, which was guided by the timeline in slide 2. Is there anything in particular that you wish to add in addition to the evidence that you had given in relation to that matter?
Indeed, there is, Chair. One thing that concerns me, and it's been of a great concern to me over the last couple of years. As we speak, the Colonel from the South African Police Service, Colonel Naveen Madhu, who had put just under 1.4 million rand in the boot of my car in an attempt to bribe me, is still at work. After that event, I was arrested and suspended. I'll deal with that. But the problem that I have is that Colonel Naveen Madhu is still sitting in the same position, dealing with the same matters, and it had been brought to my attention by a senior person from finances that some of these irregular activities after my departure still continued. Now, I cannot confirm, so I have not been able to independently verify that. But he did report that to me, and it is a very senior person from finances in KwaZulu-Natal. There are two matters. The one is the 60 million rand corruption investigation, and then the attempt to bribe me. So what happened is, Chair, when he was arrested after they attempted to bribe me, there was an attempt to have a disciplinary hearing on Colonel Naveen Madhu. However, he managed to obtain an interdict preventing the police from continuing with that particular disciplinary hearing because they'd followed the wrong procedures. But that interdict only pertains to the attempt to bribe me. Nothing up until today, in spite of myself bringing it to the attention of senior management and SABC, nothing, absolutely nothing has happened. He's still in the same position, still doing the same work. And that to me is of real concern.
Just to refresh one's memory, what was the year of the bribery case again?
Chair, it was in 2011, August 2011.
So, for about 8 years or so, no disciplinary. Well, from what you say, there was an attempt to take disciplinary action, and he obtained an interdict. And after that, as far as you know, nothing happened.
Nothing happened, Chair. And over and above that, while I was still in office, I received information, and I canvassed this with the then head of the Hawks,
Yes.
General Anwar Dramat. I had information that I will be suspended on a specific date, and that Colonel Naveen Madhu had now been suspended for the attempt to bribe me, would return on a certain date. And those 2 dates I conveyed to General Dramat. And lo and behold, on the day that I was told that Madhu would return back to work, he returned back to office.
Yes.
He was temporarily removed to another office.
Yes.
But within a month or two, he's placed back into his position. And on the exact same date that the prediction was, and those predictions came from none other than the main suspect in the investigation, Toshon Pandey.
Yes.
He predicted the exact day on which Naveen Madhu would return back to office and the day that I would receive my suspension notice.
Yes.
Chair, if I may, I humbly apologize for the interruption, but Should General Booysen perhaps be sworn in again, or is it
No,
not necessary?
it's the same oath continues.
Thank you.
Because he had not finished his evidence. It's different if he has finished and he comes back for cross-examination.
Thank you, Chair.
So you say you had raised the issue with the, in any event, just to be honest, so in any event you confirm that you are still under oath that you had took previously, and you will continue to give your evidence under the same oath.
I accept that I'm still under oath, Chair.
Yes, thank you. Now, in terms of the people at SABC or people within whatever structure internally to whom you had reported this for purposes of any disciplinary action, are you able to say this is to whom I addressed correspondence or spoke, this is who I spoke to, and these would be the people who would have taken decisions, or is that something that you are not able at this stage to indicate?
Chair, as recent as late last year, I was phoned by a colonel in KwaZulu-Natal who was desperate to talk to someone, and that was a Colonel Myburg. Colonel Myburg had also reported corruption emanating from the office of Colonel Naveen Madhu. There was a protracted investigation, and the net result of that investigation was that they were going to charge the whistleblower, Colonel Myburg. So I flew to Durban, and I had a conversation with the acting provincial commissioner, General Mkhonazi, and he stopped that process. But during that discussion, I did detail to him the fact that Naveen Madhu had managed to obtain an interdict for a disciplinary hearing pertaining to the attempted bribery. But that does not preclude them from continuing with a disciplinary hearing against him for the main charge of the 60 million rand corruption, which is fully implicated. And that the same applies to the captain that works with him, Captain Narain Prasad.
And you don't know what happened ultimately with that interdict, because an interdict will normally, and I assume it was just a temporary interdict, and from what you have said, there was some procedural problem or something. You don't know whether it was discharged or fell away at some stage, or whether it's still in existence?
Chair, what typically happens in SABC, if they want to get rid of you, they follow the procedure.
Yes.
Or they attempt to follow the procedure. And I'm speculating now, the way they treated the disciplinary hearing of Madhu, it was a paper exercise. And obviously, that being a paper exercise, they would remand it, and then they would stop it, and eventually, when they wanted to proceed with the matter, just before I was going to give evidence, he went to the Labour Court and applied for an interdict, which was granted. I think it was a final order. And because the police had procrastinated with the proceedings. And quite rightly so, Chair. I mean, what's good for the goose is good for the gander. So I don't have a problem with that interdict. The police didn't follow the necessary, their own rules. But the problem that I do have is, in the other matters, absolutely nothing was done.
Well, in any event, it seems to me that certainly within SABC or the Hawks, somebody should look into that issue thoroughly and see why there seems to be nothing that has happened in regard to the other matters, but also to look at the one relating to the interdict, because obviously I have no knowledge of the interdict that you talk about, but courts would not lightly say somebody mustn't be disciplined at all when there seems to be evidence. You know, they might say follow the right procedure if you want to discipline. You know, so somebody might need to look at that carefully. who would be the right person? Would it be the head of the Hawks
No.
ultimately, who would have the ultimate responsibility to check these things and
Chair,
see
it
if
would-
somebody is not doing their job?
It would be the provincial head for support services in KwaZulu-Natal,
Yes.
which I recall as Major General Ngembe.
But they would all fall under the head of the national head of the Hawks or not?
No, Chair, because Madhu does not work,
Or
he's not with the Hawks.
Or he is
He's with the
SAPS, with SABS, yeah. But ultimately, the National Commissioner of SABS would be able to talk to whoever at provincial level that needs to investigate and see what's happening.
If it's brought to his attention,
If it's brought to his
Chair, I
attention.
don't think the current National Commissioner is aware, but
Yes,
the provincial management in KwaZulu-Natal is
Yes.
blissfully aware.
yes,
And the fact that he's still in the same post, they did not even think it prudent
yes,
to at least put him in a different department where,
Yes.
where there can be no attempts to commit.
yes, yes. I think the legal team should, while we are busy with the investigation, maybe through the acting secretary, just bring the matter to the attention of the National Commissioner of SABS to say that Major General Boycen raised this concern about a matter that he's giving evidence about, for the National Commissioner to look into it and see whether there isn't something that is happening that should not be happening. And I'm sure he would let the Commission know what was found out. Thank you, Major General Boycen, for
Thank you,
raising
Chair.
the issue. Thank you.
Sorry, if we could then resume where we left off, and that is then on page 23 of Exhibit ZA.
I must just check, Ms. September, you have a soft voice. Let me check if they can hear you at the back. Are you able to hear Ms. September at the back? They say, I think they
I'll
wish you
speak a
to
little
raise your
louder.
voice a bit, yeah.
In that case, let us resume at page 23 of Exhibit ZA.
Thank you.
General Boycen, following the evidence that you gave in relation to the Toshon Pandey investigation, you then addressed two additional investigations, one which you've termed to be the Amigos investigation, and the other which was the looting of the Secret Service account. You then turned to the Cato Manor investigation, and when last this matter was heard, you had sketched a factual background in relation to the investigation. To this end, can I ask you to turn to Exhibit ZG, which is the new bundle that has been placed before the Commission. So from your main affidavit at page 23, you deal with the Cato Manor investigation very briefly, and that is but in 2 paragraphs, which is at page 75 and 76. Since our last hearing,
Paragraph 75 and 76,
correct, Chair.
I think you said page.
Oops, paragraph 75
75
and
and
76
76.
on page 23.
Yeah.
Since the last hearing, a report has been publicized which relates to the inquiry in terms of Section 12(6) of the National Prosecuting Authority Act, and the unabridged version of that report is contained as Exhibit ZG. This particular report relates to the Commission, which was chaired by Justice Mokoro.
I think it's called inquiry. I don't think it's a commission.
Thank
It's
you,
an
Chair.
inquiry in terms of the National Prosecuting Authority Act.
Thank
A
you.
commission will be a commission under the Commissions Act of 1947.
Apologies for my error.
Yeah.
This report related to the inquiry which was chaired by Justice Mokoro. For ease of reference, we'll refer to the report as the Mokoro report. Have you considered this report, General Boycen?
Chair, I've perused it, more specifically in the passages that deals with the Boycen matter.
Yes, thank you.
And it is correct that you gave evidence at this inquiry.
Indeed, Chair.
Just to clarify the context of this particular report, if I ask you to turn to page 14. At paragraph 12, it reads that the scope of the terms of reference was to look into the fitness and propriety of both Jiba, being Advocate Nomqobo Jiba, and Mkhwebi, being Advocate Lawrence Mkhwebi, to hold office in their respective capacities. In relation to Jiba and at the panel's discretion, the inquiry was to consider evidence arising from the cases referred to in the terms of reference. It is correct that the matter which is referred to in this report as the Boycen evidence is the evidence relating to the racketeering charges related to the K2 Manor investigation. Is that?
That is so, Chair.
Thank you. Chair, while we place this entire report before you and tender it as evidence, we will not deal with or detract from the particularity or detail in the report, but simply highlight certain evidence relevant to this witness, so this witness can then augment some evidence that was not necessarily placed before the inquiry.
Well, you place it before me as nothing more than simply a report of the Mokoro inquiry, isn't it?
Yes.
You place it for no other purpose other than that it's a report of that inquiry. What we make of it is another matter.
Yes, Chair.
Yeah, that's my understanding. I'm just pointing that out because you said you place it before me as evidence. So I think that might cause confusion. I think you place it before me for what it is, a report of the Mokoro inquiry.
As it pleases, Chair.
Yeah. If you place it for any purpose, you can come back and tell me what that other purpose is.
Okay.
Okay.
Then let me ask General Boycen, in considering the parts of this report which relate to you, do you have any comment on the accuracy of the evidence as it's recorded in here which you gave at the inquiry?
Chair, with regards to where my name appears in this report, it correlates with the evidence that I gave at the Mokoro inquiry, the Justice Mokoro inquiry.
Yes, thank you.
Okay.
So to the extent that it might summarize, or it might purport to summarize the evidence that you gave at that inquiry, as far as you're concerned, it correctly does so. It correctly summarizes your evidence.
That is my case,
Thank you.
Mr. Chair.
Okay.
And accordingly, Chair, to that extent, we do not intend to lead all this evidence again, but rather just augment certain aspects of it to the extent necessary.
Well, I haven't read the report. I paged through. From where to where does the report deal with the issue that Major General Boycen refers to?
Yes, I will take us through the relevant excerpts with your leave.
Yeah, well, if you first tell me where I find it.
No problem. The first reference of the pertinent case relating to General Boycen is at page 58. It is, in fact, a synopsis of the case of Boycen versus Acting National Director of Public Prosecutions and Others, 2014, 2ALL, SA 319 KZD, which was delivered on the 26th of February 2014 by Justice Gorvin.
Is this not a summary of the judgment as Justice Mokoro and her panelists understood the judgment?
Correct, Chair. That very judgment appears...
Because that doesn't need Major General Boysen's confirmation as correct.
Not at all. I'm just pointing it out that that is one of the aspects. In fact,
I want you to identify the part of the report which Major General Boysen has talked about as a correct summary of the evidence he gave at that inquiry. That's what I want you to identify.
no problem, Chair. If we go to page 97, of the same exhibit,
Yes.
that deals particularly with the Boycen case. It relates to pages 97 to 143, which starts at paragraph 295 to 453, in particular to General Boysen's evidence.
I see at page 106 where it says Boysen's version. Is that the one
Yes.
you talk about
Yes,
as Boysen's evidence?
yes, Chair.
Is that what you're talking about?
Yes, Chair.
So, which part, is it this part that you and he are talking about when you say is a correct summary of his evidence before that inquiry? It's important to identify that part.
Chair, perhaps I can assist.
Yes.
I'm referring from page 96 to page 143.
96 to page 143.
That's correct, Chair.
Is that the same that you have in mind when you asked him that question? Is that the same?
Not particularly.
Not particularly, but that's what he is talking about, that we know now. Which one are you talking about when you were asking him the question?
General Boycen is indeed correct to the extent that evidence relating to his matter is contained in, from page... Hello,
Oh,
I don't know what
looks
happened.
like the,
Hello?
we might have to take, are we back? Yeah, it looks like we are back. Okay, just continue, or then it goes again. Okay, it looks like we are back. Okay, pages 96 to, just repeat, Major General Boysen.
Chair, it's 96 to 143, but in addition to that,
Yes,
there are also sections
of the report.
in the latter part of the report at the findings,
Yes,
which I highlighted and which I
which you go along with.
that's indeed so, Chair.
Yes, they fall outside of the pages you have just mentioned.
Yes, Chair.
Do you want to mention where they are if you do know? But if you don't know, she will help us later on. I thought you might have it.
Unfortunately, it's on my phone because I numbered them on my phone.
Okay, later on that can be done.
Okay.
Okay.
If I could perhaps just clarify,
Yeah.
from 96 to 143, it is a consolidation of all the evidence in relation to the Boycen matter.
Yes.
To the extent that it consolidates the evidence, there are parts of Boycen's evidence which is included at different intervals. There is also a dedicated section which is at the page Chair directed us to, which is page 106, and that is specifically to his version. So my understanding is that when General Boycen considered these paragraphs, and I'm happy for him to confirm this too, he agrees that where any evidence that he placed before the inquiry is recorded in the report
Yeah.
in the bigger context of the evidence as consolidated. That evidence is in fact
Is
accurate.
accurately
Recorded.
reflected.
Yes, Chair.
Okay. Major General, that's what you say, that to the extent that the report refers to evidence that you gave in the Mokoro inquiry, it reflects your evidence correctly.
I confirm that, Chair.
Okay, thank you. Then later on you can identify, maybe prepare a piece of paper that identifies where one can find all of those parts.
As a
Thank you.
In that instance, can we then start off at page 96? It's correct that the purpose of the evidence in relation to the, or rather paragraph 94 records that this particular section, which deals with your matter, hones in on nuanced aspects of the Boycen matter, if I may refer to it as such, and deals with the issue of racketeering authorizations. The purpose of the evidence is not to evaluate or determine the guilt or innocence of Boycen in relation to the criminal charges you are currently facing, but rather to consider with reference to the terms of reference vis-à-vis the lawfulness of the decision taken by JIBA to authorize the prosecution of Boycen for racketeering.
I confirm that, Chair.
Okay. In other words, all facts that are then contained in here augment paragraphs 75 and 76 of your affidavit on page 23. If we could then look at page 97.
Well, didn't you want him to confirm that?
He does, Chair. He
You
does.
do?
I
Okay,
confirm that, Chair.
thank you.
At page 97, paragraph 296, it is recorded that the evidence before the inquiry...
Well, since we're dealing with two exhibits at the same time, just repeat that you are now referring to exhibit ZG, so that there's no confusion as to which one of the two exhibits we are dealing with now.
Thank you. Exhibit ZG, page 97, paragraph 296. It is stated that the evidence before the inquiry relates to the following, and it's fourfold. The first is the authorization by JIBA to charge Boycen with racketeering. The second is the lawfulness and propriety of JIBA's conduct in ordering that the prosecution of Boycen and others in the K2 Manor Unit be done by a team of prosecutors from outside KZN. The third is the involvement or lack thereof of Advocate Simpiwe Mlotshwa, together with instructions to him ostensibly either at the behest of JIBA or at the very least with her knowledge and consent to sign an indictment in the absence of supporting evidence. And lastly, Mlotshwa's removal as acting DPP and the appointment of Advocate Moipone Noku in his stead is dealt with.
I confirm that, Chair.
From page 98 of the same exhibit, at clause 5.2.1.2, the powers of the DPP to prosecute outside of their jurisdiction is addressed, in particular from paragraphs 297 to paragraph 303 on page 102.
I'm sorry, I'm confused. You are referring to page 98 of Exhibit ZG.
Correct, Chair.
The best part of that page consists of a quotation from section 179 of the Constitution, isn't it?
Yes, Chair.
Is that what you are referring to?
Yes.
Or have I missed something?
My submission is that the recordal in relation to the considerations of the DPP to prosecute outside of their jurisdiction, which General Boycen need not comment on, is dealt with in paragraphs 297
Okay.
to 303.
Okay.
The offense, if we're now on page 102, which deals specifically with the offense of racketeering and the judgment of Govan J. Okay. And so to just for the record, the offense of racketeering is dealt with only in 2 paragraphs, which is 304 and 305. When one then looks to page 103, if I can take you to clause 5.2.1.4, it talks about the process of evaluation of racketeering charges within the NPA.
Is that the paragraph of the report? 5.2.1.4.
It appears to be a subsection. Just above paragraph 306.
Yeah, okay. Yes.
General Boycen, you've given evidence that you have extensive knowledge in relation to racketeering and process. Is that correct?
That's correct, Chair.
Do you have any comments in relation to the process of evaluating racketeering charges within the NPA, based on your experience in the service?
Chair, I've read this passage from the inquiry. I can confirm that the evidence that was laid at the inquiry, not by myself, it was a statement by Advocate Mamabolo. I confirm the procedure that he describes in his affidavit. In my experience, I was surprised to see that this procedure was not followed in the Boycen matter. As head of the Hawks in KZ, in the procedure, and I'm going to try and use an analogy of a narcotics investigation. The investigators would start a project on narcotics. Once it starts to look that there could be a possible case of racketeering, I just want to add that in each province we have advocates, which we call organized crime advocates, that work with the Hawks. This advocate and the investigators would then, at regular meetings that we have in terms of progress in projects, would then allude to the fact that this might be a case for racketeering. That advocate will then basically give instructions to the investigator as to what evidence is required.
Guide to the investigators.
That's right,
Yes.
Chair. Once they are satisfied, from my office, we will then contact the national office. At the national office, previously, I actually dealt with Advocate Mamabolo and Advocate Johan Kruger. They were dealing with a desk where through these racketeering cases had to go before it's presented to the NDPP for authorizations in terms of the Prevention of Organized Crime Act. In my experience, and the Savoy or the Amigo case is a case in point, where the investigators were sent back several times from national to obtain more and relevant evidence to establish the enterprise, number one, and number two, to link the individuals to the enterprise, individually and collectively. So, and it's true what Mamabolo says, Advocate Mamabolo says in his statement. He says normally that procedure would take 14 days. Chair, if you look at the correspondence, the application to prosecute myself and Kate Manor for racketeering, I think, landed on the desk of Advocate, I think it's Anthony Mosing at the time. And within a day, I think it landed on his desk on the 15th, and on the 17th, the racketeering charges were authorized. So
It was an unusually short period that was taken.
absolutely,
Yes,
Chair.
yes. Okay, thank you.
And that is in fact confirmed on page 105, paragraph 320, which reads that the process, which is preceded in paragraph 313 to 319, was not followed in the Boycen matter, and no explanation has been provided as to why the accepted process was not followed.
Have you, since the time that instruction was issued, have you ever been told or given an explanation why, in your case, this took such a short time? Either through your own inquiries or through your lawyers inquiring or through any affidavits that may have been filed at some stage in court?
No, Chair, I did not.
You've never been given any explanation?
I might have mentioned it in my founding affidavit, Chair, or in any of my supplementary affidavits in the review application.
Yes.
But I cannot recall specifically asking why was
Yes.
my matter dealt with so
Yeah.
quickly within the space of one day, as opposed to
Yes.
other cases that I personally dealt with my investigators that normally took longer than 2 weeks.
Yes.
Advocate Mamabolo says 14 days. In some instances, it actually took much longer than that.
Yeah.
But I've never pertinently asked the question,
Yes.
and I've never been given obviously never gotten an answer.
You say you did pertinently ask the question.
No, I did not.
No, you
Chair.
didn't, yeah. But you say you are not sure, you may or may not have raised the issue in some affidavit.
I suspect I might have,
Raised
Chair,
it.
but over the
Yeah.
last 6 years, I've made
Many affidavits.
6 founding affidavits, replying affidavits, and supplementary affidavits. So I might have mentioned it somewhere.
Well,
but
it may be important to establish whether in any of the court applications that you made, you raised the issue as part of challenging whatever you were challenging, and to see whether it was dealt with in response, and if so, by whom and how. So that might be important to establish. So maybe if you still have access to all your affidavits, it might help to just check.
I'll check. I do have all the affidavits,
Yes,
Chair.
yes, thank you.
Thank you, Chair. If we can then turn to page 106. And at subparagraph 5.2.1.5, which is titled Boycen's version, that is in fact the version that you tendered before the inquiry. Is that so?
That's so, Chair.
Okay. And in particular, at same page of 106, paragraph 323, the last line reads that Mahema is a DDPP based in the Northwest Province and who was appointed to the Boycen matter by Jiba. Paragraph 324 reads that at the time he was charged, according to both Boycen and Padayachi, he was working on a particularly sensitive and high-profile case, namely the Toshon Pandey investigation. And this case involved a multi-million rand corruption investigation against wealthy businessman Toshon Pandey. He is alleged to have had business links to direct family members of Zuma, presumably former President Jacob Zuma.
Yes, Chair.
325, first sentence says the case also concerned procurement irregularities within the South African Police Services. And 326 confirms that the charges against both Mado and Pandey were subsequently provisionally withdrawn. At paragraph 327, mention is made of an article that appeared in the Sunday Times, which stated that Cato Manor SVC section was a, in inverted commas, death squad. The article also accused Boycen of being complicit in their alleged actions. Do you have any comments in relation to this particular article that appeared in the Sunday Times and the context within which that occurred?
Basically what happened is photographs were used by the Sunday Times, and the two journalists responsible for that was Stefan Hofstadter and Mzilkazi wa Afrika. Now, Chair would recall when I testified when Colonel Madu attempted to bribe me when I met him the first time. He showed me certain photographs. And I don't think it's any coincidence that those very same photographs were the photographs that eventually appeared in the Sunday Times.
Okay.
On what basis do you draw the conclusion that it was not a coincidence?
Well, Chair, it stands to reason. I saw the photographs, well, not all of them, the whole file, on the laptop that Naveen Madu showed me. And I also had a discussion with Mr. Stefan Hofstadter in my office before they published the article. And I still took issue with him, and I said to him, look, the photographs that you guys have, not all those people were shot by Cato Manor. And the one, probably the most gruesome picture was the one of, I think, 4 or 5 people deceased on the back of a bakkie, where Cato Manor had not been involved. They actually tended to the scene. So I found it very suspicious that the very same photographs that was used to put pressure on me now all of a sudden appear in the Sunday Times. And the reason why I'm saying that is it later became evident that it was indeed a member from crime intelligence that colluded with the Sunday Times. There were also intercepted communications between Pandey, Tashan Pandey, and Mzilkazi wa Afrika, where certain photographs and CD discs were promised, which obviously which I was privy to. So it was clear to me, Chair, and there is also a statement, and I cannot recall the name of the person who actually stole the photos. Chair, these photographs were actually photographs at Cato Manor on the computer system, which they logged. Those photographs came from the dockets, the case dockets. And the reason why those photographs were kept is in a number of instances where robberies had been committed. And incidentally, we had one last night where a person shot a police colonel about 3 months ago in Durban. And this very same person was shot and killed last night in Johannesburg during a robbery case. So that's one of the reasons why they keep those albums, to identify suspects that had become deceased that were involved in other cases. There is a statement in one of the dockets where the person who stole these photographs, it was done so at the behest of Colonel Madu, with the involvement of another Colonel, Rajen Iyer. So the only escapable conclusion one could come to is those photographs were shown to me on the computer to put pressure on me. There's evidence that they were stolen for a particular purpose, and the next moment they appear in the Sunday Times. So that's why I come to that conclusion.
But just to go back to your evidence earlier in regard to those photographs, when Colonel Madu showed them to you, is my understanding correct that you never asked him, why are you showing me these photographs?
Chair, I asked him what it was all about.
Yeah.
Because it did make sense to me. He showed me photographs which I could probably given him thousands of.
Yes.
And then he just said to me, no, you can get some more of these.
So he didn't answer what was the point of him showing you these photographs.
Well, I did, Chair. I said to him, well, what's this all about? These are normal police photographs. It's at that point we closed the laptop and he said, no, you can get more of these photographs. So I said, well, get more.
Yes, but what I'm saying is, from what you are saying, it seems to me that he didn't give you an answer to your question. My understanding is that your question was, I'm paraphrasing. What's the point of showing these photographs? Is my understanding correct?
He didn't give me an explanation, Chair.
But that was, in effect, the question you put to him?
Yes, Chair.
And he didn't give you an answer to that question?
No.
Yes, okay. Thank you.
Thank you, Chair. So just to confirm, the conclusion of coincidence that you draw is your conclusion?
That's my conclusion, Chair.
To continue on page 107 of Exhibit ZG, paragraph 328, it's recorded that Boycen was then suspended from duty. He successfully challenged his suspension in the Labour Court on 2 occasions. Next.
I'm sorry. You went to court a number of times, I think you said, is that right, in regard to your suspensions and criminal charges against you, is that right?
Chair, if I include the disciplinary hearing and the SCA matter that was abandoned by SABC, I think it's probably about 7 or 8 times. But to court, to High Court and Labour Court, I think 6 or 7 times.
Yes. That must have been quite expensive in terms of lawyers.
Very expensive, Chair.
Yes. Okay, thank you.
To then quickly deal with your suspensions. When were you first suspended, General Boycen?
Chair, just after the Sunday Times article appeared in December 2011, obviously we had the Christmas period, then nothing happened during December. Then early, and I think it was early February, I received a notice of intention to suspend me, and I had to advance reasons why I should not be suspended.
And this was what year now, February? What year?
2012, Chair.
Yes, okay. And at that stage, the notice would have come from whom? Provincial person?
No, that came from National, Chair.
Would it have been the National Commissioner of Police?
At that time, no, it was from General Dramat.
Oh, okay, all right, thank you.
So, Chair, early mid-February, I received this notice of intention to suspend, but the notice was very vague. So I wrote to SABC and I said, I need more information to make a meaningful representation. I cannot make a representation if I do not know why I'm been suspended. And I received a letter back from...
After all, I think if somebody is considering suspending anybody, they are the ones who must give the basis first. Why are they thinking of that in the first place?
Indeed, Chair.
So that then you can address those issues rather than simply saying you must say why you should not be suspended without saying why they are thinking of suspending you in the first place.
That's indeed the case,
That should
Chair.
apply to everybody.
So, Chair, their response was very curt, saying that, well, there is enough information at my disposal and they're proceeding with the matter. So I went to the Labour Court and applied for an interdict because of the paucity of the information in the notice. The police did appoint counsel, but by consent the order was granted. And the order said that the police cannot suspend me unless, and there was a list of questions that they had to answer. I never received those answers. There was a very amateurish attempt. A couple of the, I think 7 or 8 questions were answered, but in no particular sequence. And I wrote back to them and I said to them, look, it's unacceptable. You still have not complied with the court order. And I think it's about 3 weeks later, I was called in and given a notice that I'm now suspended. And I still said to the General...
Without answers to those questions?
Without any answers to those questions, Chair. I still said to the General who handed me the suspension notice, I said, well, there's an interdict, and she just shrugged her shoulders. And I phoned my attorney right there and then, and I proceeded to his office, and we work throughout the night to apply for an urgent a court order to set aside the suspension, to declare it unlawful, Chair.
Just before you proceed, just to make sure one gets, understands who the players or the actors were in this context. Now, you said the notice to, the notice asking you to make representations why you should not be suspended came from General Jamat.
That's correct, Chair.
Was it him also who made the decision that you should be suspended? The suspension that you are now talking about, which you and your attorney were looking at challenging?
Chair, in my view, de facto it was him. No, de jure it was him, but de facto it was someone else.
Oh, okay. I'm sure you'll explain how that came about.
I think I'll probably later on in my
due
evidence.
course, that's fine.
Because I firmly believe that General Dramat was under pressure from the then Minister, Natim Tetra, the Minister of Police at the time. And I'll say later on, I'll explain that later on.
Yes.
So, Chair, just to recap, I obtained an interdict against SABC not to suspend me unless they provide me with the necessary information that I require to make a meaningful representation. They do not supply all of the information. We correspond to and fro, and we tell them that we're not happy with your response. Next moment they suspend me. I immediately went back to court and applied for the suspension to be declared unlawful and to be set aside. I recall it was a public holiday the following day, and the judge still said, look, this is a public holiday, it's not going to impact on the applicant myself, and that is giving SABC until 3 o'clock that following afternoon to tell him why I should not grant the order. And 3 o'clock the following afternoon, I received a call from my attorney, and wherein SABC requested me to withdraw my application, and they will withdraw the suspension, which I declined. I said, no, I would like to see you in court, and we'll make it an order of the court.
I mean, that didn't make sense. I mean, you went to court because they suspended you. If they wanted your application not to proceed, they would just have to withdraw the suspension, not the other way around.
Not much of what they did at the time made sense.
Yes.
And I insisted that I wanted to go to court and have it declared unlawful. And we went to court the following day, and my suspension was set aside, and the contempt proceedings against SABC was remanded sine die.
And so there were contempt proceedings that you had brought in the meantime as well?
Well, I brought them simultaneously
with your application the basis of the contempt proceedings was that the suspension was in breach of the first court order, which had said before they could suspend you, they had to answer those certain questions. And you were saying they were in breach of that court order because they suspended you without complying with that requirement.
That's indeed the case, Chair.
Thank you.
Thank you, Chair. What then happened during September 2012?
Chair, then I went back to work, and
maybe before we proceed, what happened to the contempt proceedings? Because at some stage, some finality would have been required.
Chair, they were remanded sine die. I did not pursue that. For the simple reason I was bogged down with litigation, and it was basically a fight for survival. So I never pursued that.
Yes. But from your own understanding, would that mean that it may still be pending, or was it withdrawn, or formally, or
Chair,
do you have any recollection?
Chair, at one stage I did canvass this with my attorney, Mr. van der Merwe, but that was much later when I had more time, and he said to me, look, Johan, I don't think it's going to be appropriate at such a late stage to pursue this, so I just left it.
So you don't know whether it was formally withdrawn, but you effectively abandoned it.
I abandoned it, Chair.
Yes, okay, thank you.
Thank you. General Boycen, what then happened during September of 2012?
Chair, then, sorry, which month?
During September of 2012.
So, Chair, after my suspension was set aside, I went back to work and continued with the investigations, and then in September 2012, I was arrested. I was detained for one night, went to court the following day, released on bail. Bail was not opposed, and I went back to work, and then about a week or two later, I was suspended again. And this time, Chair, I thought it would be a futile exercise to now again try and set aside the suspension, because that suspension went hand in hand with me being arrested for a criminal offence.
And did that suspension result in a disciplinary hearing being convened?
Chair, no. In terms of the police regulations, once you are suspended, a disciplinary hearing should commence within 60 days. So there was no disciplinary hearing. What in fact happened is, in the meantime, I'd taken the JIBA authorization on review. And then after Judge Gorwin ruled in my favor, I said, now I'm going back to work now. And then that following week, it was during the evening, I was served with papers. And that was, I still recall, I think it was 600 days later, instead of 60 days later. General
It was 600 instead of 6 days later.
That's correct, Chair. So what kept me out of office was the criminal charges hanging over my head. When the court ruled in my favor and the charges were withdrawn by the state, I thought I could go back to work. And then belatedly, 600 days later, 600 odd days later, I was served with papers for a disciplinary hearing.
That would be 600 days would be more or less 2 years.
2 years later, Chair.
And was there ever any explanation why this was being done so late in breach of this 60-day requirement?
Chair, when the hearing started, we raised a point in limine, objecting to the procedure being followed. The chairperson overruled us, and then I said to my attorney, let's just place it on record. If the finding eventually is adverse to me, then at least we can take it on review. We have placed it on record. Fortunately, it turned out that I was exonerated during that disciplinary hearing, which lasted 6 months.
And who chaired that disciplinary hearing?
It was a senior counsel, Advocate Nasir Kasim.
To that end, can I then take you to bundle ZB? And that's page 442. Or rather 443, sorry. Four, 443. This document is marked as findings. If I can ask you to then turn to page 470. Is it correct that the conclusion of Advocate Nasir Kasim, SC, was that the employer has not discharged the onus of demonstrating wrongdoing on the part of the employee, Major General Johan Booysen? And at paragraph 77, in my view, it would be unjust not to forthwith reinstate Boycen to his position as Provincial Head of Priority Crime Investigation in KwaZulu-Natal so that he can do what is best suited to do, that is, fight crime.
That was the finding, Chair.
While we are dealing with this particular finding, I ask you to turn to page 44. Sorry, paragraph 44, which is at page 457 of the same bundle. paragraph 44, the findings of Advocate Nazir Kasim SC reads that I found Colonel Aya to be a dismal witness in material respects. He is obsessed by the notion of his own importance, and his entire testimony was permeated by his political acceptability and self-importance. I find him not to be the kind of professional policeman one would expect holding the rank he holds. His tenor of evidence, as I have indicated above, is one in which he emphasizes his own importance, but lacking in conduct justifying his usefulness. I think those in charge of the SAPs ought to carefully perhaps consider Colonel Aya's continuous role in the police force. In his quest for acceptance and self-importance, he is determined to tarnish Boycen's reputation and dignitas, irrespective of the cost to the overall interests of the police force. If in fact the employer party actually believed that it could establish a case against the employee based on the evidence of Colonel Aya, this was a serious error of judgment, and worse still, a strong indication that the employer sought to create a case where one did not exist. Who exactly was Colonel Aya in the context of the racketeering process that was instituted against you?
Colonel, sorry, Chair, he's the key witness in the racketeering case. I've been charged under E and F of poker, and F being that I managed the enterprise. So, whereas he was the actual unit commander at the time, he now becomes a witness against me. I don't know how he can be a witness. He should have been a 204 witness. But he's now the key witness against myself and some of the Cato Memorandum members, in that we managed a criminal enterprise. His statements were ventilated in the matter the review matter which I brought in front of Judge Gorvin. And my contention at the time was that the statement that he had made at the time, well, he had made three, Chair, and all three are very incoherent, to say the least. It related to office politics. There was no indication of any offense being committed whatsoever. And my assertion was confirmed by Judge Gorvin that it only relates to office politics. And much later, when Advocate Abrams became the NDPP, he procured a legal opinion from two of his advocates, one being a senior advocate, Advocate Jan Ferreira and Advocate Van Eden, in which they had to give him a legal opinion as to why they should proceed with criminal charges against Advocate Mokoro in my matter. And in that particular legal opinion, which I managed to obtain because it became part of court papers in another application by one of these non-governmental organizations. In that particular legal opinion, both those advocates from the National Prosecuting Authority actually confirms, or they don't confirm, they agree with what Judge Gorvin had said, what I had said, confirmed by Judge Gorvin, that it only relates to office politics. And it's this very same Colonel Ayer that Advocate Sean Abrams is still relying on, because he much later, and I'll testify about that later, in spite of the court order, reauthorized my prosecution. But he still remains the key witness for the state.
So charges have been reinstituted against you?
That is indeed the case, Chair.
That is from when? When did that happen?
Chair, it was reinstated, I think, February 2016.
Yes, okay. Thank you.
So, Advocate Nazir Kasim's findings, which is dated the 16th of September 2014, is released. Do you return to work?
Chair, I've now been exonerated by Advocate Kasim in a disciplinary hearing. The court had found that there was no case against me. Fortunately for myself, the Constitutional Court at that time, the Glenister matter, said that myself would now report to the national head and the national head to the minister. Whereas in the previous era, I had to report to both the provincial commissioner and to the national head, and the national head of the Hawks also had to report to the national commissioner. So that was all taken out of the equation. So I decided, I phoned General Dramat and I said, look, I'm going back to work now, and he agreed with me. I then received a phone call from General Dramat that I need to come to Pretoria, where I had to meet with him and the then National Commissioner, Ria Piega. General Piega called me into her office, myself and Dramat, and she gave me 3 options. She said to me, either you must remain at home on special leave, or you should take a transfer, or you should take Section 35. Section 35 is a golden handshake. I still had 3 years left in the police service, so she was prepared to pay me out for 3 years. And then I said to her, well,
If that happened, if you had gone for that route, that option, what it would have meant is that, one, the country would have paid you for 3 years for staying at home when you could have been working. That's one. Is that correct?
it's actually worse than that. Because at that stage, I'd already been sitting at home for 2 years.
Yes.
So another 3 years. So the state would have had to pay me.
Yes.
And
5 years.
despite what a lot of people say, the police generals get a generous salary. The taxpayer would have had to pay myself sitting at home for 5 years.
Yes, yes. But also in relation to the 3 years, if you had taken that route, they would have had to appoint somebody else in your position and pay that person for that 3 years. So during that 3 years, they would have been paying 2 people for the same job.
And that's indeed the case, Chair.
So, but that's one of the options she offered you.
That's what she offered me, Chair.
Yes, okay.
Chair, so I told her, at that stage, she told me she's taking Advocate Cassim on review. So I said to her, well, you need to file a record for me to oppose it, which up until today she hadn't done. But then she said to me she's going to give me a month to think about it. A month later, I went back, and she called me into her office once again, and this time around, she already had the brigadier from Finance Services level documentation for me to sign. So I said to...
To sign for what now?
What's either the transfer or the Section 35 golden handshake.
Oh, yeah.
So Chair, she asked me, so what did you decide? So I said to her, option number 1 is not an option. I'm not going to stay at home any longer. I've been sitting at home for 2 years already. And then she said to me, option number 2, I said, I'm not going to take a transfer. Then she said to me, so if I give you a lawful instruction to transfer you, you're not going to comply with my instruction. I said, no, that's not what I'm saying. Then she said, what are you saying? I said, well, if you transfer me, I'll take the matter to court. She said, why? I said, because you cannot transfer me. Then she said to me, well, who can transfer you? I said, General Dramat can transfer me in terms of the Glenister judgment. Then she asked the Dramat, what do you say, General? And then he said to no, he agrees with me. At which point then the whole tide changed. Then she started arguing with him. And then when it got to the point of the Section 35, the golden handshake, then she said, what about that option? I said, no, I'm not going to take that either. And then she said to me, why not? I said, well, I'm still reasonably fit and young, and I think I can still make a contribution to fight crime in KZN. And at that time, the cash and transit heists and the political killings had spiraled out of control. And I said to her, crime is out of control in KZN. And she said, how can you say that? I said, well, your own divisional commissioner, as recent as last week, made a statement in the Daily News newspaper that he need to send task teams to KZN to deal with these crime matters. And then she said to me, before I excuse you, is there anything else you would like to say? So I said, no, there is something I would like to say. I got up and I said, I'll be back in my office tomorrow. And then I walked out, and then I had to wait for General Dramat. And I could hear through the walls that it wasn't a pleasant meeting. Then Dramat eventually came out and we left, and he said to me, Piega wants to know what makes me tick. I said, what makes me tick is let me do my work. That's what makes me tick. He said to me that she's requested that I don't go back to work and that I take 2 weeks leave. So,
What for?
Chair, they just didn't want me back at the office. They just didn't want me back at the office.
Did General Dramat tell you whether he asked her what for?
Chair, General Dramat's a very soft-spoken person, and he's not confrontational. But he was 100% behind me going back to work.
Yes, yes.
And I agreed with him. I said to him, look, what I'll do is I'll take 2 weeks leave. But I'm going to go back to my office. I'm going to report back for duty. Because I know how they operate. If you stay away, then they'll say, no, you acquiesce to the process of staying away. Now you're back. So I said, I'll go back to work. Then I'm going to apply for leave for 2 weeks. I'm going to send it to you. You must approve it. That means I'm back at work. And then he said to me, how can we overcome this impasse? I said, let General Nkumbeni, the provincial commissioner at the time, let us all have a round table with the National Commission. Let's sort this thing out. So a month later, we had this meeting, and this meeting turned into a debacle, to say the least.
Now, the general that you referred to is Ngobeni, the provincial commissioner.
Yes, Chair.
And this was after the incidents. Obviously, yeah, it was after the incidents where she called you and said stop the investigation and so on and so on.
Yes, yes.
Okay. Yes. All right.
So they convened this meeting with General Piega, General Makubela, who since passed away, General Dramat. There was another general from legal services, I cannot recall her name, Rantu. She was sitting across, and I could see from her demeanor that she wasn't even interested in this thing because she knew what was going on was wrong. She was on the phone. Don't know whether she was texting or playing games or whatever, but she had no interest in this meeting, and quite rightly so. And then, Chair, it wasn't a meeting. The more I tried to
Just again, who was at this meeting?
it was General Ria Piega,
Yes.
General Dramat,
Yes.
who was with me, and General Makubela, who's a
Yes.
lady.
Yes.
She subsequently passed away.
Yes. The commissioner, provincial commissioner, was not there.
She was also there.
She was also
there.
This meeting was convened pursuant to your suggestion that
That's
there
right,
should
Chair.
be
Yes.
a roundtable meeting.
Yes, Chair.
Okay, all right. Maybe we'll take the tea break now, and then we resume. Let's take the tea break. It's 20 past. We'll resume at 25 to.
Thank you, Chair.
We adjourn.
All rise.
I have to finish. I don't have a choice.
Yes, Mr. September, you may proceed.
Thank you, Chair.
I think Major General Boycen was in the middle of his evidence when we had to adjourn. I think he may proceed from there.
Thank you, Chair. It was your evidence that you then returned to work following the finding of Advocate Nazir Kasim.
That's right, Chair.
We were dealing with, if I recall correctly, but I may be mistaken, what happened after that roundtable meeting that you talked about, and you returned to work after that. Is that right?
That's right, Chair.
And as I understand it, you returned with an intention to apply for leave or fill in leave forms which would have to be considered by General Jomat.
That's right, Chair.
Okay, thank you.
Thank you, Chair. Following your return to work, were there any further disciplinary steps taken against you?
Chair, when I returned to work, I called in the investigators. Obviously, I wanted feedback as to how all these investigations had proceeded in the time that I'd been out of office, suspended.
And you had been out of office for how long, by the way?
About 2 years, Chair, just over 2 years.
So it was a long time.
A long time, Chair.
Yes.
So, Chair, it was clear to me that, well, number one is the attempt to bribe me by Pandey and Madu. That matter had been withdrawn by Advocate Moipone and Noko. The main case, the 60 million case, that case was declined to prosecute by, I think it was Advocate Abby Lecholo from the Durban office, in spite of the fact that there was overwhelming evidence. Chair, there was even a forensic report which cost the taxpayer 1.93 million rand from PricewaterhouseCoopers, in which it's clear from that report there were approximately 20 arch lever files and over 200 affidavits. And in spite of all that overwhelming evidence, Advocate Lecholo declined to prosecute. Then there was the matter...
Just one second. Maybe for the record, you can help with the spelling for Lecholo, or are you not able to?
Chair, left to right.
If you are not able to, that's fine. Maybe some other time somebody will.
I'm gonna second guess, Chair. I don't think I'm gonna get it right.
But anyway, you say there was an investigation, a forensic investigation by PricewaterhouseCoopers,
Chair.
Yes. And that investigation would have been authorized during the time you were not there?
No, Chair, what happened just before I was suspended, the investigators told me the scope of the investigation was of such a nature that we would have to get forensic auditors involved. And then we applied to National Head Office. At the time, the National Commissioner was the now Minister of Police,
yes.
Mr. Becky Cele.
Yes.
He approved it.
Yes, yes.
And that particular report, Chair, SABC was invoiced 1.93 million rand for that report.
Yes.
And the conclusion of that report was that there was definitely corruption committed by
yes.
the people that we were investigating.
Yes. So, but there was a decision not to prosecute, notwithstanding that. That's what you say.
Indeed, Chair.
Yes. When you returned to work, how long before that had that decision been taken, if you are able to remember? How
Chair,
old was it?
Chair, I think it was quite a long time before I returned back to work.
Okay, all right.
If I can just interject there. Yesterday when we consulted, there were certain documents that was that you referred to. Chair, it's not included in the bundle, but with your leave, if I may, hand these documents up.
What are
please. The one document relates to a submission by Advocate Noko in relation to the withdrawal of charges in the corruption matter against Mr. Toshon Pandey and Colonel Naveen Madhu.
Okay.
And the other is a memorandum, apologies, the other is a response by General Boycen to that particular memorandum.
Okay.
And these were documents that he called for upon his return to
Okay.
office.
Okay, thank you.
I'll be guided by you as to how you
we-
wish to
We
mark
should,
them.
we can, maybe we should have them dealt with. We should have them put separately. Because the ones that you already have here, they are referred to in his affidavit. These ones are not referred to, isn't it?
No, it's not, Chair.
So I think we'll need to, you have got Exhibit ZA and ZB, is that right?
Yes, Chair.
And then
And it runs to ZG.
you have got ZG as well. Have you got the other alphabets in between?
Yes,
Have you
Chair.
got C, D, E, F?
Yes, Chair.
Oh, okay, then we should make Advocate Noko's, is it Advocate Noko's submissions?
Yes, Chair. That's the one at
That
the bottom.
memorandum, we should make it Exhibit Z H. Exhibit Z H. H will be in brackets because you have put the others in brackets. And then Major General Boysen's, I think it's in the form of a letter.
Yes, Chair.
Letter responding or dealing with that, dated 19 November 2014. We'll mark that Exhibit ZI in brackets. Yes, thank you.
Thank you, Chair.
Those of the witness, have they been marked or not? I'm sure he'll be able to mark them. He has dealt with these, with exhibits for many years. You understood which one I said would be Exhibit ZH, that is Advocate Noko's submissions, Exhibit Z, and in brackets H, and your letter which contained your response, Exhibit Z, I, and I will be in brackets. Thank you.
Thank you, Chair.
Thank you, Chair. If I could then quickly refer you to Exhibit ZH, which is the memorandum that was prepared by Advocate Noko in relation to the withdrawal of charges.
But before we go there, just one clarification. So this briefing that you asked for from the people under you, did it happen before you went on leave or before you went on leave?
No, it's after my 2 weeks leave, Chair, I went back to work.
Oh, okay, so it was after.
After, Chair.
Okay, yeah, I wanted us to clear that part as to where it fell. Okay, so your leave was, you went back to work, you filled in the forms for leave, and General Dramat approved the leave.
That's correct, Chair. And for that 2 weeks in my absence, I appointed Brigadier Fleck,
Yes.
who was the second most senior person at the time, to act in my absence for those 2 weeks.
Yes. During the time that you had been suspended for 2 years, was there somebody acting in your position? And if so, who was it?
Chair, there was a brigadier, can't remember his name now, Brigadier Mboto acted in my place in
Yes,
those 2 years.
yes. Because I assume that whatever issues you would have dealt with in regard to these matters would then have fallen to be dealt with by him in your absence, being the person who was acting in your position during that 2 year period.
Chair, I would have expected that to happen,
Yeah.
but it did not happen.
It did not happen, yeah, okay. And I assume you had no hand in, no role in his appointment as to act in your position.
None whatsoever, Chair.
Yes, but generally, you would be the person empowered to appoint a person to act in your position if you were away, or would that be
Chair,
somebody else's power?
Chair, in normal circumstances, I would appoint a person to act in my absence if I go on vacation leave.
Yes,
or,
yes.
But in this particular instance, I think, well, once you suspend it, you don't have any say.
Yes, 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 yes. Okay, thank you.
General Boycen, it was your evidence that when you returned to office, you called for a reporting on the status of investigations.
That's correct, Chair.
If you could look at Exhibit ZH, which is the memorandum prepared by Advocate Norco dated 21 October 2014. Is this a memorandum that was placed before you when calling for a status update?
This was one of the documents that was placed before me, Chair, when I wanted an update from the investigators as to
Yes.
After considering this particular document, it is understood that you then prepared Exhibit ZI,
I did, Chair.
and that letter under your hand is dated 19 November 2014.
That's correct, Chair.
Okay. Can you please explain the basis of your letter and the objections that you had taken as documented in your letter?
Maybe let's start with this. Do you want to, in relation to Exhibit ZH, that is the memorandum by Advocate Norco, do you want to highlight any particular features of her submissions that you think are important, that may have struck you, that you may have decided should be dealt with in one way or another?
Chair, the general gist of Advocate Norco's report, if I can summarize it, it looks like it was written by a defense attorney rather than a prosecutor for the state. It's as if she looked at any possible excuse, and some of the stuff she basically made up. I mean, that's why I say in one of my paragraph 2, assertions are an aberration which lacks substance supported by credible evidence. Some of them are blatant untruths that she placed on record in a report.
And that was paragraph 2 of Exhibit ZI, which is your letter.
That's paragraph 2 of my letter, Chair.
Thank you.
Well, Mr. September, it's important to deal with the gist of the submissions by Advocate Norco and at least the gist of Major General Boysen's response. Somebody listening needs to know what it was about, what was its purpose, and to the extent that she may have been saying the withdrawal of the charges was justified, or the charges should be withdrawn for this and that reason. At least the important features must be dealt with so somebody listening can follow. No. And then the response, what Major General Boycen may have said about some of those reasons.
No problem, Chair.
Even if it's not everything.
No problem, Chair. The response that was prepared by General Boycen is quite specific to the paragraph referenced in Advocate Norco's submission. And if, with your leave, if I may then take him through the points as he referenced it.
Yeah,
and
but
his
not
objections
necessarily
to it.
everything, the important points.
Okay. General Boycen.
Or maybe he has not had, both you and him, he have not had time to look at the important ones.
Chair, all those paragraphs are
quite important.
Are quite important because it's evident from Norco's memorandum that this is a contrived document.
Let's deal with them. Let's deal with everything because it may be quite an important issue. So let's deal with the submissions from Advocate Noko, and then let's deal with them fully. It's okay.
As it pleases, Chair. If we could then look at the documents simultaneously. Your first issue, as taken in paragraph 3 of your letter, relates to paragraph 2.3.
That's correct, Chair.
Sorry, maybe before we do that, I think in paragraph 1, she indicates, I understand she says it's a lady, is that right?
That's correct, Chair.
Yes. She indicates what this document, what the purpose of the document is. She says, I had previously provisionally withdrawn this matter on the basis that there were considerations of justice that I had to look into in order to arrive at a proper decision that is in the interest of justice. These have been so looked into, and my decision is indicated hereunder with substantiation. So she had provisionally withdrawn the matter. And she had said so, according to this, that she needed to look into certain considerations of justice. She now says, I've had a chance to do so. And then she says, her decision is indicated hereunder. And she says she's giving substantiation for her decision. What was her decision that she gives hereunder? You would have known because you know the matter.
Chief, I can respond to that. She confirms why the case against Pandey Madhu was withdrawn, the attempt to bribe me. Then they go into the main case, the 60 million case, as to why there was going to be no prosecution. But what she does not say in this report of this is after she initially withdrew the charges against Pandey and Madhu, the investigators reported to me, and that carried on for almost 6 months, that she refused to return the docket to them.
But the memorandum, I haven't read the memorandum, so I'm thinking in case you have read it, in the memorandum, does she confirm the decision to withdraw the charges?
Yes, Chair.
Is that right?
That's right, Chair.
So the reason, the substantiation that she is talking about, therefore means she's giving reasons to justify her decision to withdraw the charges.
That is the case, Chair.
Against Pandey and Madhu. Yes, okay. I think that's where then everyone understands we are looking at the reasons. What reasons did she give for the decision to withdraw? Okay, deal with that.
For the benefit of those listening, paragraph 3 of your letter, or rather, let me start off by saying paragraph 2 of your letter makes a general statement to say that this missive from Advocate Noko is rather verbose. It is permeated with conjecture, innuendo, inaccuracies, and in certain instances, blatant untruths. The assertions are an aberration which lacks substance supported by credible evidence.
No, Ms. September. Let's hear what the reasons are that she gives first. Then we can go to General Boycen's critique of that if necessary.
Would you like me to address all of the reasons and not just those that he objected to or took issue with?
Yeah, well, let's do that. This might be very important.
Okay. With your leave then, Chair, it is quite a technical document. Could I then read the paragraphs as indicated into the record? General Boycen does raise issues with very specific paragraphs, and not all of them, but I'm guided by your direction, Chair.
If it's possible, then maybe we need to skip this part. Maybe during the lunch break, have a look properly at these two documents, and then after lunch, let's deal with these properly. I'm sure you'll find a way that we deal with them without reading them.
No problem, Chair.
Okay, because maybe you haven't had enough time to look at them.
No problem, Chair.
Okay, so let's return to that part after lunch. I think to the extent necessary, we you may just be able to say there was that submission by Advocate Noko, and Major General Boycen, having read it, was unhappy with the reasons given, and he gave his comments in this submission that we'll deal with later and then proceed.
As it pleases, Chair. With your direction, we will then deal with that, the submissions and later,
Yeah.
at a later stage,
Yeah.
after lunch.
Yeah.
General Boycen, you return to work. You go on leave. Were there any subsequent disciplinary steps that were taken against you following your return to work?
Chair, perhaps I should just contextualize my response to Advocate
question.
Mokoro, because that's what now led to
Yes.
a further suspension.
Yeah.
So
If you deal with it without dealing with this,
Yes.
it takes
Yes.
away the context.
Yes, Chair.
It takes away the context.
Chair,
Yes.
I can just perhaps summarize that.
Yes, but let me just say what I'm looking for. I want to be told these were the reasons given by Advocate Noko for the decision to withdraw. A, B, C, D. Okay? Then, because you responded to that, you then say, in regard to A, I didn't have a problem, B, I didn't have a problem, but I had a problem with C, D, and E. And my problem with C, D, and E were the following: bang, bang, bang. That's the kind of thing I'm looking for. I haven't read this because they only got handed up now, so I'm not able to assist. To assist. If you are able to do it that way, do it that way. If you are unable, we may have to read them, throughout all the pages.
Chair, I will attempt during the lunch break to do as you request.
Yes.
But I think for purposes of answering the
continuing,
question,
you need to say something.
I wrote this to the newly appointed National Director of Public Prosecutions,
Yes.
Advocate Kasana.
Yes, okay, yes. Also, your exhibit, the exhibit ZI was directed at Mr. Kasana.
That's the case.
Yes, he was the new NDPP at
Yes,
the
Chair.
time. Okay, yes.
I then also went to General Dramat, and I told him that I'd written this
Yes.
report. And he said to me he had also written a report to Mr. Nkasana
Yes.
on very similar lines.
Yes. And the purpose of your letter, which contained your views on the Noko submission, the purpose was to get that decision reversed. Is that right?
That was my position, Chair.
That was your, yes, okay, continue.
So, Chair, and also at the very same time, I received a phone call from the head of ICD, then IPID now, the Independent Police Investigative Directorate, Mr. McBride. And he asked me what was going on, and I gave him a report. And because of this, also the report by Dramat and McBride, I don't know whether McBride wrote a letter to Mr. Nkasana or whether he paid him a visit. But nevertheless, I was then asked myself and the accountant for PricewaterhouseCoopers to come to National Head Office, where we did a presentation to advocates from that Advocate Nkasana had appointed to have another look at these cases that had either been withdrawn or nolly prosecuted. A specific advocate was appointed at the time. It was Advocate Gary Nell. He had started interviewing witnesses. He had visited some of the witnesses in KZN. And we were about to embark upon basically prosecuting the majority of the people mentioned in those investigations. Then it was after the appointment of the Major General Burning and Tlametsa, He was then appointed head of the Hawks. After Dramat had been...
Oh, okay, let's get this sequence correctly. You return to work after the 2 weeks leave. You get briefed on matters that were ongoing when you were suspended. And in regard to the Pandey Madu matter, you get finished with Advocate Noko's submissions as to why it was justified to withdraw the charges. You prepare comment on that, the purpose of which was to have that decision reversed so that the prosecution could proceed against Mr. Pandey and Colonel Madu. And at that time, General Dramat was still the head of the Hawks. When you
That's
prepared
correct,
that letter.
That's correct, Chair.
Yes, but after that, after some time, he was suspended or removed, or he left.
So,
Is
Chair,
that correct?
This is where things get complicated because in
Yes.
that December, I think it was the 24th of December, just prior to that,
And just mention the year as well, because there
Okay.
are too many years we are dealing with here.
Chair, so it was 2014.
Yes.
Yeah, 2014. So I just returned to work, given the reports, written these reports. In that interim period, I cannot recall the exact dates, there's another Sunday Times article that appeared by the same two journalists, Hofstadter and Afrika, accusing General Dramat and General Shadrach Sibia, and there's another colonel, I cannot recall his name, I think it was Kumalo, I'm not too sure, accusing them of so-called rendition.
Yes.
And they were accused of extraditing Zimbabweans without extradition papers. And that's another chapter, Chair, which I'll,
Yes,
which I will
yeah.
talk to a bit later. Then Dramat got suspended in
Yes.
December that year.
Yes.
And immediately, after he was suspended, they appointed as acting head of the Hawks, Major General Burning and Tlametsa.
Yes.
He acted for a period of time, and then in that period, Dramat agreed with SABC to leave SABC on a special dispensation, and then the post for head of the Hawks was advertised. I applied for that. Myself and 3 others were shortlisted for that post. We were flown down to the then Minister of Police, Mr. Nati Nkleko's office at Parliament to be interviewed for the post. Tlametsa wasn't there. It was myself, 2 ladies and a gentleman. We completed our interviews on the day, and a month or 2 later, Tlametsa was appointed as the head of the Hawks.
Do you know whether he was an applicant for the position at the time you were interviewed?
Chair, I don't know,
Yes.
because normally what he would say in public and what actually happened were 2 different things. What I do know is in an open meeting in Polokwane, with a meeting with all the provincial heads
Yes.
and other senior managers from the Hawks,
Yes.
he said that he did not apply for the post.
That is Ntlameza.
And Tlametsa said that personally at a meeting at Polokwane.
Yes.
Now, whether he just said that and applied or not, I don't know, but that's what he said.
That's what he said, yes.
But he was not present on the day that the 4 of us were interviewed.
Yes.
Now, whether he had applied and whether they had a separate session with him, I do not know.
You don't know, yeah, yes. Okay, but you say about a month after that interview,
I'd say about a month or 2, Chair.
about a month or 2, he was appointed.
He was appointed.
Yes.
Chair, in the
But all the other people that, as far as you knew, had applied, and you don't know whether he had applied or not, were there
They
on
were
the
there,
day
Chair.
of the interviews.
There were 4 of us there, Chair.
Yes, okay, thank you.
But Chair,
So Major General Burning Tlametsa was in office, and were any steps then taken?
Chair, within, I would say, a week after his permanent appointment as head of the Hawks, I received another notice of intention to suspend me.
Okay, let's also just get clarification. General Dramat got suspended and General Clemenza was appointed to act in his position. For how long did he act before he was permanently appointed, as if you are able to remember?
Chair, I think he started acting, I think it was on Christmas Day 2014.
Yes.
And I think he was appointed permanently perhaps in July the following year.
2015.
Give or take a month or two.
Yes. Okay. So I just wanted to get a time frame. Yes. Okay. You say within a week or so after he was permanently appointed, you got a notice from him asking you for representations why you should not be suspended.
Once again, Chair.
Yes. And what was your response?
Well, Chair, this time around he accused me of committing fraud.
Yes.
And what's interesting, more or less at the same time, he also accused General Shadrach Sabia of committing fraud.
Yes.
He was eventually prosecuted and
Yes.
acquitted.
Yes.
In my matter, I wrote a letter, well, in my presentation,
I'm sorry. Was fraud the only thing that was the basis of the notice?
Yes, Chair.
Okay, all right.
The fraud-
What did it say fraud was about?
The fraud related to a monetary award, Chair, that was written by the commander of Cato Manor for work done by his members in the investigation of the killing of Colonel Tonko. The killing of Tonko, one of the suspects that was sought by Cato Manor, Makujela and Damande, they were looking for him and they couldn't trace him. I received information from an informer that he was on his way to Pietermaritzburg. I conveyed that to Cato Manor. They got hold of the surveillance unit to manage to track down Makujela and Damande. The surveillance unit then informed Cato Manor that he was on the freeway. Subsequent to that, there was a chase on the freeway whereby Makujela was shot and killed, and he had a bodyguard with an AK-47 who was also shot and killed. So my role played in the tracing of Makujela was detailed in that report. A number of detectives, and I'll guess probably about 18 to 20 detectives, did get a 10,000 Rand monetary award. Somewhere in the report, there's a wrong date. So,
What kind of award would that be? What was it for? Is it a performance bonus or what is it?
Chair, it's not really a performance bonus. It's police regulations makes provision where police officers did exceptional work, that they can be awarded with a certificate or a medal or a monetary award
Yes.
up to, I think it's 30,000 Rand.
So it was a monetary award connected with excellent performance of their duties.
That's correct. Chair.
Yes, okay.
On that particular point, if I can take you to bundle ZG, which is the Mokoro report, at page 108. Under subparagraph 5.2.1.7, which is titled Monetary Reward, it is dealt with from paragraphs 331 to 337 on the next page. Is that the monetary reward that you were referring to?
That's the same monetary award that Judge Mokoro refers to, Chair.
He must still tell us what he was still telling us about this, yeah?
So, Chair,
So the members of SABC were said to have claimed, put in claims for a monetary award.
Chair, it's not a claim, it's an application.
It's an application.
In terms of those regulations.
Yes.
Which is done by the unit commander.
Yes.
So the unit commander detailed the names of people that had been part of this investigation.
Yes.
And he sent that to me, but now the process is I would send that to my superior. He will send it to the provincial commissioner, who was General Hamilton Geedy at the time. He has a committee that sits on it. He eventually approves, goes to national head office, where deputy national commissioners, more than one, sits on a panel, and then they'll eventually agree or disagree. And in this particular instance, they agreed and awarded each of us with a 10,000 rand once-off payment award.
Yes.
The problem, according to Tlametso, was that there was a date that was wrong. But if you read the thing sequentially, it's clear that it's a typographical error. I wrote a detailed report, and I said to him, it's clear from that it's a typographical error. And I actually pointed out in his notice of intention to suspend me, he's also made similar mistakes. And in spite of a detailed report, he nevertheless suspended me.
But are you saying that was the position that General Tlemeza said, in effect, you should be charged for, or he said that you should make representations why you should not be suspended on the basis that you may have committed fraud, and the fraud that he was talking about was based on the fact that a certain date had been given in a document that you had signed. Is that right?
No, I did not. Chair, that's just the point. I never signed the document.
Oh, you never signed
because
the
document. I was a possible recipient. I did not
Yes.
feel comfortable signing that document recommending for myself, although when I sent it to my superior, I recommended that the people in that report be awarded.
Yes.
But I deleted my name as
Yes.
at the bottom, and I put
Yes.
the General Brown's name there.
Yes.
He then dealt with the matter. He
Yes.
recommended to the
Yes.
provincial commissioner.
Yes. But what was, according to General Clemenza's letter, what associated you with that date that you say was wrong?
Absolutely nothing, Chair.
And his letter didn't indicate what you had to do with putting in that date.
Chair,
Did he not accuse you of having given wrong
Jim,
information or something?
maybe if I can explain it this way, I took that decision to suspend me on review as well, and in the, this time to the High Court. And the judge in that matter, I think it was Judge van Zyl, he ruled that there's not an indication of an offence being committed, let alone by the applicant.
Anyway, you made representations to Mr. Clemenza saying, among other things, this is clear when you read the document that this is a typographical error. And you say, despite that, he still suspended you.
I also told him in my representation, Chair, that what he is saying in his notice of intention to suspend, that he's actually misrepresenting facts that could possibly prejudice me.
Yes.
And that he'll make himself guilty of an offence of fraud if he does that.
Yes, yes.
And I did subsequently open a fraud case against him, which I
Yes,
believe is now with the NDPP's office.
Yes.
But in spite of the fact that it's evident, Chair, if you read my report, that there's just no reason, there's just no valid reason for him to have suspended me.
Yes. Okay, thank you.
If I can ask you to turn to bundle ZB. And in particular, page 315. Is this the Justice Van Zyl judgment that you referred to, which at page 345 set aside your suspension and ordered that pending the outcome of any disciplinary proceedings, you will be not liable to suspension from your employment, in addition to which a punitive costs order was granted?
And that's the judgment, Chair.
Thank you.
The General Tlemeza's notice and Major General Boysen's response, are they here? Because then if they are, we must just identify them.
We do not have that.
They are not here.
Okay, no, but we can certainly.
For the sake of completeness, it might be important to have them.
I still have them, Chair.
Yeah, if you can make them available, that would be helpful, because it's important
Yes, Chair.
to see what facts you placed before him, and despite that, he made the decision, he continued with the decision.
Yes, Chair.
Yeah. Okay.
Thank you, Chair. It is correct that the suspension did result in not only being set aside by court, but additional legal action was taken.
Chair, a few things happened. Clemets applied for leave to appeal the Van Zyl judgment, which was refused, and then he petitioned the SCA. In that interim period, I indicated that I'm going back to work again, but he then indicated that they served papers on me for another disciplinary hearing.
Are you able to remember this suspension, this application that you had just won in court now, that you have just talked about, where Judge Van Zyl gave judgment? That was, what, the second or the third time that you had to challenge a suspension in court?
Chair, the very first one was the interdict that I got because they didn't give me enough information.
Yes.
And they suspended me in spite of the interdict.
Yes.
I then had that overturned.
Yes.
The second time was when I was arrested. I was suspended. I did not challenge that for obvious reasons.
Yes. Then there was a disciplinary inquiry.
Then there was a disciplinary inquiry in which I was exonerated.
Which found in your favor.
That's correct, Chair.
Yes. And then you were told about various options by General Pierre.
That's right, Chair.
And then you went on leave. Then you came back, and then there was this suspension now by General Tlemeza. So it was a second suspension, is that right? Or third?
It would be the third one, Chair,
The third one, yeah.
of which I challenged two.
Yes, yes, yes. Okay, all right. So continue.
Is that the suspension which led to a hearing, the evidence of which shall not be placed before the Commission at this stage?
That's so, Chair.
Thank you, Chair.
So you had just said that something had happened and General Tlemeza was preparing to suspend you again. Or I thought it's something you were saying that.
No, Chair,
Did I misunderstand.
No, he did suspend me.
Yes, I know about the first
It's
suspension.
overturned.
You won. He applied for leave. He was turned down. He petitioned the SCA. Was he turned down as well on that?
Well, Chair, so what happened then is, and I'm not going to give this evidence,
Yeah.
at that point in time, I've been approached by the private sector
Yeah.
and I was sitting at home doing nothing. And the matter, I was due to retire July 2017. And the matter was set down for the SCA for March 2017. And by now, I think I know how the courts work. Judgment will be reserved, and if you're lucky, I would have gotten my judgment by, say, May, June, which in effect would have meant that I would basically go back to work and fill in my retirement papers. And that I indicated to SABC that if they prepare to release me now, I'm prepared to go. They agreed. I think they were very happy to get rid of me. Well, some individuals within SABC. And I went on. I left the police in February. And
2017.
2017, Chair. And I was supposed to have left in July that year, so they paid me out for
Till
for
July.
that period of time as well.
Yes, yes. And did that form a settlement of the appeal or not?
That was part of the, Ntlemetsa and them indicated then that if that's the case, they will not proceed with the SCA application. I know, and I was privy to communication that the registrar had sent to the state attorney at the time, basically telling General Ntlemetsa that the way they dealt with this matter is not the way that the SCA works. Because
in terms of procedural issues.
That's correct, Chair.
Okay. Yes, continue.
In that instance, can we go back to the Exhibit ZG, the Mokoro report, at page 109? And just to add, Chair, in the introduction, in the initial presentation to the stream, there was a slide that was posted which informed that Major General Bernie Ntlemetsa acted during the dates of 2014 to 2015, following which he was appointed to the position of National Head of DPCI from 2015 to 2017.
What page in the Mokoro report do you want to refer us to?
Page 109, which is subparagraph 5.2.1.8, titled, Pariyachi Affidavit. Without going into the detail of what is stated from paragraphs 338 to 345, is it correct that this particular Colonel Brian Pariyachi is the same Pariyachi who assisted you in the Toshon Pandey investigation relating to interceptions and the like?
That was the same Colonel Pariyachi, Chair.
Can we then move on to page 111 of the report? Under subparagraph 5.2.1.9, it's marked the decision to authorize the prosecution and the steps taken. This particular section is dealt with at length. And to that end, you are asked, General Boycen, to please clarify as far as you are aware, the process and involvement of Mhlotshwa as the acting DPP to authorize the prosecution and the steps taken by augmenting what is already stated here.
Chair, at the time, when I was still at office before all my problems started, the actual DPP at the time was the current NDPP, Advocate Shamila Batoy. She then took up a position at the International Court at The Hague, and Advocate Simpiwe Molocha was appointed as the acting DPP in KZN. Molocha, I did not personally know him at the time, but I knew about him because some of my investigators had reported that they dealt with him. And one of the cases on which I already testified was the Amigo case, under which there was pressure on Molocha, Simpiwe Molocha, to withdraw those charges. So I knew about him, but I'd never met him. Unbeknown to me, and only established this much later, this came out that during that same period that I was busy with these investigations, Advocate Molocha received a phone call from the then acting NDPP Advocate Nonkobo Chiba, and which he said to him that because of pressure and urgency, there's certain documents that he had to sign. He was on his way to Port Shepstone to court, and he indicated to her when he arrives back at the office, he'll have a look at it, and if all the necessary documents are there, that he would sign the documents. It turns out that it was either a covering letter or the actual indictment to have myself and Cato Manor members prosecuted for racketeering. On his arrival back at the office, there was only the letter to sign with no supporting documents. He then wrote an email to, I think it was Advocate Chauke.
Would the letter that he was expected to sign have been a letter to authorize your prosecution?
It would have been a recommendation, Chair.
It would have been a recommendation
Yes.
that you be prosecuted.
That's correct, Chair. So
Okay.
normally the DPP, in spite of the fact that the NDPP must authorize a POCA prosecution in terms of racketeering, it remains the responsibility of the DPP to sign the indictment. So it was the accompanying letter with the indictment that I suspect that he had to sign. But he indicated in an email to Chauke, well, look, I'm not going to sign this thing until and unless it's clear from the supporting documents which individuals are linked to the criminal enterprise individually and collectively. There was communication between Chauke and Mlotshwa to and fro, in which it became evident that Advocate Mlotshwa was not comfortable to sign the documents. At a later stage, there was a meeting at National Head Office, at the National Prosecuting Office, where Advocate Chauke told Advocate Simpiwe Mlotshwa that Advocate Jiba wanted to see both in our office. Advocate Jiba once again asked him what the problem was, and he said he's happy to sign it, but he needs the supporting documents that links us collectively and individually to the criminal enterprise. The meeting was adjourned, and the next moment, a while later, Advocate Mlotshwa was replaced by Advocate Moipone Noko. Now, Chair,
How soon after that, if you are able to say?
Chair, I'll have to guess, but it wasn't very long after that.
Yes, okay.
But Chair, a lot of things happened simultaneously now, because there's Mlotshwa's refusal to withdraw charges against Maboyikulu and Nkoyeni. There's his refusal to sign documents for our prosecution. And the next moment he gets replaced by Advocate Moipone Noko.
So just to understand, so as you understand the position, Advocate Mlotshwa, in regard to the Amico case, which related to Mr. Mabuya Kudu, among others, and Ms. Gonyeni, in regard to that case, your understanding is that pressure was being put on him to withdraw the charges, and he was refusing. And in regard to you, he was being asked to recommend your prosecution, and he was saying, until I have supporting documents that show how these individuals are linked to the enterprise, I'm not prepared to sign. That was his stance in regard to the two matters. Is that right?
100%, Chair.
Thank you.
So Mlotshwa refuses to sign without the supporting documentation. Who in fact signed the indictment? Are you aware?
Well, there were two indictments. The first one, I think, was signed by, I think it was unsigned, but I think the covering letter was signed by Advocate Noko.
So after Advocate Mlotshwa was no longer the acting DPP, and Advocate Noko had been appointed acting DPP, then your indictment was signed. Or your prosecution was
Yes.
authorized.
Well, not authorized, Chair. It was recommended to.
Was recommended.
Yes, Chair.
Yeah, okay, by her, that is Advocate Noko,
Yes,
to
Chair.
the national office.
Chair, it's somewhere in this exhibit here.
Yes.
ZG.
ZG, where I think
Where
Judge
the
Mokoro
document
actually
is.
make such a finding that
Yes.
Norco did what Malorcho did not want to do.
Yes.
There is a reference to
Let's
that.
go there if we can. Ms. September, do you know where that is or not really?
There's certainly the exchange between Mlotshwa at page 115. Mlotshwa actually testified at the inquiry. And that talks to his agreement to in fact sign the indictment without the supporting documents. And Jiba's non-interference in the exchange between him and Chauke. Is that what you refer to, Chair?
Well, it's Major General Boycen that is looking for something. I think he said it's in a judgment. Is that right? Major General Boycen?
Judge,
What you are looking for is in a
Yes.
judgment.
it's in the judgment where the judge actually comments that
Yes.
Norco did what Malorcho refused to do.
And which is it? Judge Van Zyle's judgment or Judge?
No, it's
Coven?
in a Mokoro judgment, Chair.
Oh, here, okay.
Can I perhaps have a look at that
Yeah.
and revert to you? I don't have it at
Yeah.
my fingertips right now.
Okay, look for it during the lunch break, okay?
Will do, Chair.
Yes.
If I can then take you to page 117 of the report, Mokoro report. And that's subparagraph 5.2.1.10. And that in fact confirms evidence that, unless I'm incorrect, evidence in relation to Mlotshwa's end of office. Do you have any comments in this regard?
Can you just rephrase the question, please?
No problem. Page 117, subparagraph 5.2.1.10 is titled No Reappointment of Mlotshwa. Do you have any personal knowledge in relation to that non-reappointment?
No, Chair, not personal, over and above what I've read in this finding by Judge Mokoro.
Thank you. If we can then go to page 119. And this particular subsection 5.2.1.11 talks specifically to Null's opinion, Advocate Null's opinion. Do you have any personal knowledge in relation to that?
Chair,
I'm sorry. Let's finalize. Advocate Noko gets appointed as acting DPP. What happens? Let's get that story. What happens?
well,
after
Chair,
that?
three significant things happened. She gets appointed. Within 2 weeks, she withdraw the Amigo case charges against Maboy Kulu and Peggy
Ms.
Ngoyeni.
Ngoyeni.
But 2 or 3 months later, she withdraw the charges against Toshan Pandey and
Yes.
company.
Yes.
And if one looks at the timeline, it's during that same timeline, unbeknown to me then, but known to me now, that my prosecution is recommended.
Yes. And so your prosecution is recommended by her to the acting and to the NTPP.
Yes, Chair.
At that time, who was the NTPP, Mr. Ngasana?
No, then it was Advocate Mokoro Chiba.
Or Ms. Chiba? And was your prosecution then authorized?
Yes, Chair.
Yes, and you were served with an indictment.
I was arrested, Chair, and then
You were
served with an
arrested,
indictment.
yes. Okay, continue.
If I can then take you to... Thank you. I've just been informed, page 121 of the Mokoro report, paragraph 375, which is exactly where we are now too. Thank you. So it's page 121, paragraph 375, talks to Norco having signed what she regarded to be the covering letter to the prosecution memorandum at the request of Chauke. Is that the paragraph that you were referring to earlier?
That's a paragraph I was referring to, Chair.
Thank you.
Thank you.
Yes.
On that score, And specific to the prosecution memorandum, in the outline of the procedure that needs to be followed for the purposes of obtaining the authorizations relating to racketeering charges, a prosecution memorandum needs to be submitted. If one looks then from paragraph 375, at page 121 of the Mokoro report, an address is made in relation to the prosecution memorandum specific to your case. Do you have any comments in relation to the prosecution memorandum submitted?
Do you want?
Yes. I don't want to comment specifically because
Yes.
some of the stuff I only realized and heard about ex post facto.
Yes, yes. Well, do you want to be specific about the question that you want him to comment on?
No problem, Chair. If I could ask you, just bear with me, Chair. If I could ask you to turn to page, what's this, ZA?
To exhibit Z,
ZA.
ZA.
A.
Okay.
Page 204. Do you recognize this document?
I do, Chair.
Please explain what this document is.
Chair, normally, as I've said earlier on in my evidence, once the desk at the National Prosecuting Authority, for instance, Advocate Mabolo and Advocate Kruger, if they are satisfied that all requirements are met, a meeting is then, or a session is then set down with the NDPP. At that session, she's presented or he is presented with a prosecution memorandum. How it normally works in practice is that they will also do a PowerPoint presentation and go through that in order. And there are decided cases, and I think it was in the Moodley matter, where it's not a prerequisite to read all the dockets and statements. So just a factual report, how the accused are linked.
Basically, they say this is the charge. These are the requirements for us to prove this charge. This is the evidence that we have that proves each of the elements. That's what they go through, more or less.
That's correct, Chair.
Yes, yes.
And based on that, if she's then happy or he's then happy that a crime of racketeering had been committed, he or she will then authorize
Yes.
the prosecution.
Yes, yes.
So the document that appears from page 204 until page 260 of Exhibit ZA, is that the prosecution memorandum relevant to the charge, the racketeering case against you?
The one that's signed by Advocate Norco.
Yes.
That's the same one, Chair.
And if I can then take you to page 261 of that same bundle, there's another document which appears there, which runs until page
I'm sorry, what page?
261 of the same bundle.
Of ZE?
ZA, still on ZA.
Sorry, just hang on 1 second.
It's a lever arch. It's in fact the document immediately after the document you just referred to.
But the report that I was looking at, it was at ZE. Was I on a wrong document? The report that you were asking the witness about.
Yes, the report I was referring to is in ZA.
ZA,
A.
not ZE.
ZA.
Okay, what was the page? Let's go back to it because I think I was looking at the wrong one there.
No problem. It's page 204.
204. Okay, so that's the prosecution memorandum that Mr. Chairman Boycen says was used in regard to his racketeering case.
Yes, Chair.
Is that right?
Yes, Chair.
Okay.
And if one goes to page 261 of that same bundle,
Yeah.
there's a presentation document that appears there. What document would this be?
Chair, I think I just need to correct something. If we look at this memorandum,
The one at 261?
yeah, that's a second one she signed for my second prosecution. I'm referring to the covering letter, the covering minute in the first application for my authorization.
Yes. That's the one you want to identify, want
Yes.
us to find. Okay.
Unfortunately, I don't, I'm
Do
not
you know
aware of
where?
that.
Do you know whether it is in the bundle or not?
It certainly doesn't come to mind, and I do not recall it to be included
Okay,
in the
will
bundle.
you check over the
Will do,
lunch
Chair.
break? Are you able to make the point without looking at it that you may have wanted to make about it, or you would rather make it after lunch when it has been found?
Chair, I would like to be 100% accurate. I'd much
Yes.
rather look at
Yeah.
that
Okay.
document
But
first.
your recollection is that it is in the bundle, or you are not sure?
I'm not too sure whether it's in the bundle, Chair. I've
Yes.
seen it somewhere.
Okay.
Okay.
Thank you.
If we could then deal with these documents since we have them, which is the prosecution memorandum and the presentation. Is it correct that you took certain action in relation to the detail of these documents? And please explain the context of such action that was then taken. If I could then refer you to...
I'm sorry. Let's know about the documents first. This one at 261, you say is a presentation where?
So it was General Boysen's evidence that in the process of obtaining the necessary authorizations,
Yeah,
there are two documents that need to be submitted.
yes,
The one is a prosecution memorandum,
which we have seen.
and the other is, which is the one that appears at page 204,
Yeah,
and the other is a presentation that needs to be done at page 261.
yes.
Both of these documents, if I understand the evidence correctly, are documents that were then submitted in support of the institution of racketeering charges.
That's correct, Chair. So you have the prosecution memorandum and the PowerPoint presentation, which basically encapsulates what's contained in the memorandum.
Yes, okay.
If I can then take you to page 191 of the same bundle.
I've got it.
It's annexure JWB 17. 17.
Which file are we in now?
Still the same bundle, it's Z,
ZA,
ZA.
page 1.
page 191. There's an affidavit which appears there, which is your affidavit.
That's my affidavit, Chair.
And similarly, at page 199 of the same bundle, appears another affidavit that you deposed to.
That's also my affidavit, Chair.
However, these affidavits are in fact unsigned.
They are unsigned, Chair, but those were affidavits, the original ones with my signature on, are in the police dockets.
Yes. The one affidavit is one at page 191. The other one is where?
Page 199.
199. Okay. So there are original affidavits, there are original versions of the same affidavits that are signed.
Chair, yes, I normally keep copies
Yes.
because in these type of investigations, and it has already happened,
Yes.
that statement seems to disappear.
missing, yeah.
So I keep copies, and I did not re-sign them
Yes.
because it would have had a
Yes.
different date on.
Yeah, no, that's fine.
These
you.
affidavits talk to the prosecution memorandum, and it talks to the presentation, which is enclosed below. Please explain the context of you.
Maybe for what it's worth, just in case we never get the signed ones, do you confirm that the contents of both affidavits are true and correct?
I did, Chair. I handed
Yes.
them in as part of my statement.
yes.
I confirm that they are accurate,
Yes.
and that's what I wrote.
Yes, okay, thank you.
Thank you, Chair. General Boycen, please explain the reason why you deposed to these affidavits and the context within which it was done.
Chair, when I was prosecuted the second time, obviously then we applied in terms of Rule 53 for the record of decision. And part of that then, the record would be then the memorandum and the PowerPoint presentation. When I went through the PowerPoint presentation and the prosecution memorandum, it was patently clear to me that both Advocate Mahema, who was responsible for preparing the prosecution memorandum, the second one, and Advocate Mokoro, who worked with him at the time, I was under the impression that she did the PowerPoint presentation, but it was later pointed out in court papers that Advocate Mahema prepared both, but she just represented it with him to the NDPP at the time. Chair, if you go through, now, in my experience, and I've done a number of these, if you send a docket to the public prosecutor for a decision and you do a memorandum, you write a précis of what each witness will say, and you'll describe the evidence for the prosecution and for the defense. And this particular memorandum, is permeated with misrepresentations as to what the witnesses said. There are serious omissions that should have formed part of the prosecution memorandum, but most importantly, Chair, it contains falsehoods. In some instances, Advocate, and one would not say this lightly on a platform like this, Chair, but I will say it. Advocate Mahema blatantly lies in the prosecution memorandums, and I can prove it. He says things that is part of the evidence that's nowhere to be found in the dockets. It just does not exist. I deposed of these two affidavits, and I opened criminal cases against Advocate Mahema and Mokoro for committing fraud, because they misrepresented what's contained in the dockets, and because of that, myself and the state have been prejudiced. Chair, if one go into my statement, and well, one can have a look at the memorandum and go paragraph by paragraph what I describe. I'll just cite one example. Mahema, for instance, will write in the prosecution memorandum to Advocate Sean Abrams, that Boycen, that's myself, and one of the people from Cato Manor, Warrant Officer Paul Mostert, he says in the memorandum that Boycen and Mostert conspired to kill Colonel Tonko. Chair, there's nothing of that nature in the docket. We had nothing.
So in other words, you say, he says something that's quite critical for the charge, but there is nothing in the docket that supported that statement.
Absolutely
That's
nothing,
what
Chair.
you're saying.
Absolutely nothing. What the witness says in his statement, it's a deceased witness, by the way, Chair, he overheard a conversation by two other people stating that they wanted to get rid of Colonel Tonko. And they will speak to Boycen and Mostert about it. But he says in the prosecution memorandum that it was Boycen and Mostert who conspired to kill Tonko. Chair, if he was right, then they should have charged myself and Mostert for conspiracy to kill Tonko.
Yes.
The fact of the matter is, in inquest findings, magistrates had already ruled that the number of the people that were being sought, and eventually killed, that they were responsible for the killing of Tonko. So it's a complete fabrication. When I pointed this out to them in my founding affidavit, in my review application for the second authorization, he exacerbates his own problem. He says to me, that's his interpretation of what the witness says. And I mean, Chair, we can read the statement.
He says what the statement he made, that you conspired together with somebody else to kill, was it
Colonel Tonko.
Yes.
Chair.
He says that is his interpretation of what was in the docket. And what was in the docket was certain two people which did not involve you spoke about, said something to the effect that they needed to talk to you.
They first said that they need to get rid of Tonko.
Yes, and they would talk to you about
Yes, Chair.
it. Yes. Okay.
But Chair, then in his answering affidavit, this time around he lies under oath. He says that Boycen and Mostert received money from, I can't remember, some taxi association on 3 occasions. There's nothing like that in the docket. There's nothing like that in the statement.
And he could only speak on the basis of what was in the docket. He couldn't speak on the basis of anything else.
Chair, he was speaking what was written in the Sunday Times. He was not confining himself to what was recorded in the dockets.
Yes, but what what I'm asking is whether, for purposes of him performing the function that he was performing, he was supposed to base whatever he was saying on what was in the docket. Is that right?
That's so, Chair.
But you are saying he was not doing that. He was going outside the docket and basing some of the things on what was said in the newspapers.
Chair was either making it up himself or someone told him that, but that is definitely not in the docket.
Yes.
And over and above that,
But if somebody else had told him about it, as long as that was not part of the docket, he was not supposed to rely on it, isn't it?
no, that would have been completely irrational.
He would
Chair.
have needed to get a statement from that person. That person's statement would be part of the docket.
Chair, there's another, I agree with you, Chair, there's another allegation in the prosecution memorandum that I planted an AK-47 on one of the scenes. That story was in the newspaper. There's not even a hint of evidence in any of the dockets.
And he included it.
That's part of the, Chair, there are a number of untruths,
Yes.
a number of misrepresentations where they will say what a particular witness said, but they will add to what the witness said. And there are a number of omissions where there was exculpatory evidence, which they were aware of, which they did not make part of the record of decision.
Yes.
So, who drafted the prosecution memorandum?
Chair, it was initially my understanding that Mahema drafted the prosecution memorandum and Mokoro did the PowerPoint presentation. When I addressed it in my review application, the response from Mahema was that he did both, which in my view exacerbates his problem because the prosecution memorandum and the PowerPoint presentation itself are at odds with each other. I cannot say how it could have been done by the same person, but if I give him the benefit of the doubt, both contain falsehoods, misrepresentations, and omissions.
And who authorized your prosecution?
That prosecution was then authorized by Advocate Sean Abrams.
That was the second.
The second one, Chair.
And the first?
The first one was authorized by Advocate Mokoro.
Now, General Boycen.
So, but both prosecutions were still about the same thing.
The same thing, Chair.
Yeah. Okay. Thank you.
So just to make sure I too understand, you're saying that the same prosecution memorandum together with the same presentation is what informed both authorizations?
Yes, Chair.
Okay. Now, General Boycen, why would Advocate Noku and Advocate Mahema include falsehoods in documents that they compiled for presentation in such a serious proceeding?
Chair, in my statement, I deal with a specific chapter, if I can call it that, of that's the statement that's before yourself, Chair. I deal specifically with a number of prosecutors, which I firmly believe, Chair, did things at the behest of certain individuals, which I will elaborate on when I testify on that chapter.
Yes.
Advocate Mahema and Advocate Moipone Noko were both part of that group.
Yes.
Chair, it's not the only time that Mahema lied.
Yes.
When the Advocate Jiba there was an investigation against her, consequent to the Gorvin judgment, she was charged for fraud and I think defeating the ends of justice and perjury. Advocate Mahema made a statement in favor of Advocate Jiba. In that statement, he also tells a blatant lie. He says in that statement that a witness was killed. He knows full well the witness was never killed. The witness died of natural causes. He knows it because we brought that to his attention in my first review application against Jiba. Yet much later, in an affidavit in support of Advocate Jiba, he says the witness was killed.
And did he ever provide any basis for saying that witness was killed at any stage, as far as you know?
Chair, now he just mentions in that statement that a witness was killed. I think for the uninformed who would read that statement would come to the conclusion the person was killed by Cato Man, although he does not say that in his statement.
So, but you say it would be easy for somebody to think that's what he intended saying, but you say he doesn't say so expressly.
That's my position on that point, Chair.
But you say, as a matter of fact, that witness died of natural causes, and this was brought to his attention.
Chair, as a matter of fact, right with the first review application, I think it was my supplementary affidavit, we told him that this witness has died. He even denied that the witness was dead. I sent someone to the Home Affairs to obtain a copy of his death certificate. And it's clear from the death certificate that he died of natural causes. I then, in a further affidavit, told him, here's the death certificate, clearly indicating the man died of natural causes. But in supporting Jiba in a criminal investigation against her, he says a witness was killed, and refers to that specific witness, Lawfulness.
Thank you.
If we could then...
Well, it looks like we have
It's
reached
1
the
o'clock.
point for the lunch break.
Yes, Chair.
Yes. We'll take the lunch break and resume at 2. We adjourn.
All right. in the GP report, paragraph 438, I think he touches on it. 438?
Page.
No, no, paragraph.
It's
Paragraph
412.
No, no, if you go to 438, he talks about what GP was
48
charged for
what?
prosecution.
Paragraph?